Welcome everyone to this webinar. It's great to have you here today, focusing on normalising open norms, presenting some really exciting work that we've commissioned through Knowledge Rights 21 from the Centre for Intellectual Property and Policy and Management at the University of Bournemouth. My name is Stephen Weiber. I am Director of Policy and Advocacy at the International Federation of Library Associations and Institutions, and we are one of the partner organisations in Knowledge Rights 21, a drive to make sure that the voices, the experience, the needs of researchers, of educators, and the libraries that support them are heard in policy making. A lot of our work is focused on specific policy areas where we think that copyright frameworks and others can be improved. But what's really exciting, I think, about today's presentation is that we're beginning to look not just at individual policy areas, but actually a different way of thinking about how we do copyright in general, and how do we move towards an approach that is flexible, is based on principles, and actually therefore reflects and better adapts in order to follow the needs of researchers around the world. So we'll shortly hand over to our presenters from the University of Bournemouth. But in order to give you a little bit an introduction to the issue, I'm going to present a short video that we've been happy to actually commission and to work on, and a short video that we've been happy to commission that I think sets out, as I said, some of the issues here. So I'm just going to get the screen up in order to present on this and make sure that sound is shared. So if you give me a second while it loads up, I will then... Yeah, there we go. So enjoy. Great, so there you get some initial ideas about what we're talking about when we talk about an open norm. Now, what's really exciting about the research that's going to be presented today is it's a really good practical look, a really powerful look at what has the actual experience been. So now I'm very happy to hand over to the University of Bournemouth, to our colleagues from there. I will let them introduce themselves. They will do it better than I will. And so first of all, I'm going to hand over to Danusha Mendes. Danusha, over to you.
Thank you, Stephen, and good afternoon, everyone. I'd like to first of all start off by saying many thanks to Knowledge Rights 21 for awarding the project to us. It's been a real privilege and an honor to carry out this project, looking at copyright and open norms in 7 jurisdictions. So along with myself, there's also Benjamin White, who's a PhD candidate at the center, and Dr. Taki Hong, who is a lecturer and a member of CIPPM as well. So together, we will present our research, and I will kick off with giving a short introduction to the project, and then we'll go through each of the 7 countries, or each of the 6 countries, the 7th being USA, which we have looked at the fair use model, and then from that we are looking at how other countries, more importantly, have adopted, used these open norms and what those impacts have been. And then finally, we will conclude with some findings and also policy recommendations. So moving on to my first slide, if we go to the next slide. So I just want to start with some definitions. So in the video, you saw, for example, explaining about copyright and exceptions, and what we can do with sometimes without getting permission from the copyright user. And that's such an important thing. And so open norm is what we are saying is that it's a general, flexible exception to copyright. So some exceptions in certain countries are quite restrictive. It kind of also highlights the kind of work that you can do. So it will say, for example, this exception is actually applicable for criticism and review, or for private study, or for quotation, or other things. Whereas very open-ended open norms or very open-ended exceptions tend to they don't actually specify what kind of work you can use it for. It is open-ended. So one of the open-ended open norms is that one from the USA, which is fair use. And as you can see here on the slide, it generally says, as long as you can justify the purpose and the character of the use, as long as you can justify the nature of the copyrighted work, the amount that you have taken and the portion that is used, and the effect of that work that you've taken, the copyrighted work you have taken upon the potential market, then you're okay. So it is a very flexible exception. And USA is not the only country to have such an open-ended exception. And as you see in the research today, in the presentations today, you will find out about countries such as Japan and Canada and South Korea, Sri Lanka, Singapore, all these countries, and Israel that have used these open-ended exceptions or open norms. So next slide, please. Okay, so what are the benefits of having such a open norm, or what is the benefit of having this like a general flexible exception? Well, first of all, it can respond quickly to technological advances, and that's really important in the technologically advanced world that we live in. You don't have to wait long periods for a lawmaking process. I mean, lawmaking takes a lot of time. So when you have, and if you can go back, please, to the slide. So if you have this kind of open-ended exception, then basically you can, you don't have to wait those long periods. And also as a result, it can allow for reasonable adaptation to changing circumstances. One of the questions that's asked is, are these open-ended exceptions or open norms compatible with what's known as a three-step test, the Berne Convention's three-step test? And the answer is yes. And it has been tested many times. So first of all, the compatibility was confirmed when the USA joined the Berne Convention in 1989. It was confirmed when the USA joined the TRIPS agreement in 1994, and it was reconfirmed by a WTO ruling in the year 2000. So there are many benefits to having these very open exceptions. It allows the creative industries to progress. It allows the cultural industries to progress. Like I said, it's not restrictive. It allows us to move ahead with technological advancements, and it is also compatible with the Berne three-step test. So if we move on to the next slide, I'll say a few words about how we have structured our research and the methodology that we use. So when we looked at these countries, we categorized them into two broad categories. We looked at mixed legal systems or hybrid with some form of hybrid influences. And basically, we categorized Canada, Israel, Singapore, and Sri Lanka into these mixed legal systems. As you can see, next to Israel and Singapore, there are asterisks, and that's because they are common law sort of countries with hybrid influences. And then we have civil legal systems such as South Korea and Japan that have also adopted open norms as well. There is sometimes a myth that civil law countries don't do very well with open norms, but as we will show you in our research and in this presentation today, that is a myth. In reality, and as you will see, civil law countries like South Korea and Japan have very successfully adopted these open norms. And in doing our research, we first of all did a literature review, and then we had the privilege of meeting with national experts from these 6 countries, and really we call them verification meetings to verify and to truly understand how these open norms have been used, adopted, and the impact they have had in those countries. So what we really tried to respond to in our project was to understand the motivation of these countries for adopting these open norms, how a country transitioned to an open norm, the benefits and the challenges that those countries may have experienced in adopting an open norm, the impact of those open norms on education, technology, research, library sectors, and we'll say a few words about that, and the interpretation of those open norms by the judiciary. And if you can click again, please, Ben, a couple of times. And one more time as well, please. Thank you. So as you can see, we also were really interested to understand the adoption of open norms during the pandemic. So did countries that had these open norms benefit more? Like, were they restricted in accessing library materials? Or, for example, accessing materials when we could not go to libraries, when we could not access materials, did those countries benefit from having open norm? We were not really able to sort of answer the question very well. But anyway, we will come to that. But as you can see, broadly, we try to respond to adoption, impact, and use of open norms in these countries. So moving on to the countries. So I'll hand over to my colleagues who will now look at Canada, Israel, and the other countries. Thank you.
I'm sorry, I was on mute. I'm sorry. I was saying that I'm part of this project team, and I did a research on Canada and South Korean part of this project. So I'm gonna take you through what we found about Canada in terms of like adoption and use of open norm in this country. So hopefully everybody can see this slide well. So in Canada, the way they implemented also like introduced open norm was probably a bit different to other countries, because what they tried to do was basically to embrace open norm with existing fair dealing instead of introducing like a new statutory provision or per se. So basically there were two major milestones in this process. One was the Supreme Court decision of the CCH decision. The court basically broadened the interpretation of the scope of fair dealing in 2004. And then again, after 8 years, the Parliament introduced the Copyright Modernisation Act 2012, and this really enabled the Canada have a very research friendly environment for researchers and libraries. So of course, like it's more like an ongoing process, but I just wanted to just highlight that these were the major milestones in the development of open norm in Canada. So I'm going to go, in the next slides, I'm going to go I'm going to go and discuss it like much in detail. But I just wanted to show you some like landscape here, like broadly first, and then I can go into detail. So after the introduction or embracing open norm with existing fair dealing, and the decision, the first decision was in 2004. And after that, open norm was more consolidated with a series of Supreme Court decisions later on. So in 2012, there were 5 Supreme Court decisions, which is quite rare in Canada because 2004 decision was the very first Supreme Court decision on fair dealing. But there were 5 Supreme Court decisions in the year of 2012, and then 2 of them mainly discussed the fair dealing. So the court decisions, they confirmed the ruling of the CCH decision, so they tried to consolidate this concept in Canada. And the immediate effect of these cases and these rulings were that it enabled the community of educators and researchers to build their own standard, basically enabling them to have a user-centric practice and also allow them to effectively self-regulate the sector. So let's see the provision of fair dealing in Canadian Copyright Act. So basically section 29, 29.1 and 29.2 provides fair dealing provision. So section 29 says fair dealing for the purpose of research, private study, education, parody, or satire does not infringe copyright. And 29.4 suggests like criticism or review as usable purpose for fair dealing, and section 29.2 provides news reporting as part of this purpose. So I highlighted education, parody, or satire in blue. That's because it was the effect of the introduction of the Copyright Modernisation Act in 2012. But before then, the fair dealing, there were only two available purposes. Here, research and private study in section 29. But the Modernisation Act introduced the three more purposes here: education, parody, or satire, just to make sure that there are many different purposes that can be used for fair dealing in Canada. So it was more of like a legislative response, legislative action to broaden the scope of fair dealing. When it comes to interpretation of the section, the court has to firstly determine whether the dealing is for one of the statutory purposes, such as it's like for research, private study, education, parody, or satire. So this is quite different to for instance, the US approach, because US approach, they don't necessarily have to determine whether there are any specific purposes. But although the Canada is, like transitioning to an open norm, however, they still have to ask whether the dealing is for one of the statutory purposes. And then next, they have to decide whether the dealing is fair. So if we look at the CCH decision, so basically the CCH decision is one of the most important cases on fair dealing in Canada. So if I give you a bit of background information of this case, so basically the claimant, more precisely the respondent of this instance, CCH, were publishers of law reports and other legal materials. So the defendant, or more precisely the appellant of this incident, the Law Society of Upper Canada, was a non-profit corporation operating a reference and research library. So basically the defendant provided an on-demand photocopy service for a selected group of customers. And the claimant argued that that providing on-demand service constituted copyright infringement, and in response, the defendant argued that it was fair dealing. So the Supreme Court had to decide whether whether it constituted fair dealing, and what is the meaning of fair dealing, and how they interpret all those purposes. What is very interesting in this case was that the case provided a legal and theoretical ground that fair dealing can turn into an open norm. So the court said the fair dealing is not merely a copyright defense, but a user's right. So this statement gives the court to actually move forward to broaden the interpretation of the scope of fair dealing. So the court said because this is a user's right, they have to take a liberal approach in interpreting the meaning of the statutory purposes to ensure that users' rights are not unduly constrained. So based on this observation, the court tried to understand the meaning of research. So the court said, so when it comes to the meaning of fair dealing for the purpose of research, it should be interpreted quite broadly. And then they said, lawyers carrying on the business of law for profit are conducting research. So they do, for instance, look at some legal materials, and they have to, sometimes copy some materials for the purpose of advising clients, giving opinions, arguing cases, and preparing briefs and factums and everything. And all those things are basically fall within the definition of research in the fair dealing provision in Canada. And although the library actually did not do this. However, the library support was basically to facilitate all these things to happen. Therefore, the library's action providing on-demand service could be also part of research. So the CCH decision also set out how to assess the fairness of the dealing. So the court considered a number of non-exhaustive factors, including the purpose of the dealing, character of the dealing, the amount of the dealing, any alternatives, also the nature of the work, and finally the effect of the dealing on the market for the work. But what's really important here is that because this list is non-exhaustive factors, and the court can use more criteria to decide whether the dealing is fair or not, and they are not necessarily having to stick to those criteria all the time. So it's quite flexible. That's why they also try to make it really flexible in that way. So after the CCH decision, the open norms started to be like a consolidated. So CCH decision in 2004 basically set all the background for enabling this fair use, fair dealing to be an open norm. And then, as I mentioned, into 2012, after 8 years, there were 5 Supreme Court cases, and of which 2 of them was quite likely relevant to fair dealing. And these cases also confirmed the ruling of the CCH, and they approached the fair dealing in a very liberal way. So these are the cases like a Salkin and Bell Canada, Albertine Canadian Copyright Licensing Agency. These cases are the Supreme Court cases. And also, as I mentioned, because those cases give some space for researchers and libraries to provide services as they wish in accordance with this, this criteria and this like a standard. So they started creating very much user-centric practice, and they can enjoy the flexibility they can get from this open norm and broad type of fair dealing. So the immediate effect of this was, as one of the national experts mentioned, it increased the role of copyright expert and specialist at Canadian institutions. And then the statistics show that before this decision, around, for instance, in 2010, there were like only 4 institutions where those specialists were hired. However, in 2016, almost all Canadian institutions have copyright experts and specialists, and they create their own practice standard in accordance with this, flexible open norm. So the next part will be Israel, and Ben will take us through with this part.
Hi, so can you hear me okay? My name is Ben White, and I'm the 3rd author on the project. So Israel until 2029 still essentially operated UK copyright law. So it was the 1911 Act of the British Copyright Act, which was operative. And essentially that provided one line which said that fair dealing was permissible for research purposes, private copying purposes, news summary purposes, and criticism and review. However, before introducing fair use, you had in 1993 a landmark case in the Israeli Supreme Court, which via case law introduced the 4 factors that we know from fair use. In 2005, the next background stage was an explanatory memorandum from the Knesset explaining that the introduction of fair use was to avoid stagnation in copyright by giving courts greater interpretive freedom to resolve unforeseen uses. And we know from our national experts that they were involved in discussions with the Israeli Copyright Office around making Israeli copyright more flexible and supporting sort of commercial innovation also. So those of you that are familiar with fair use will look at this and see this is pretty similar. 19A, B, it's pretty similar to fair use. We have at 19A examples, I don't know what's happening with this slide. We have examples of the types of uses that could be fair. And then we have the 4 tests, which we know from US law. So pretty similar in terms of their transplantation of US fair use. What was particularly interesting is C. So the final section, which says that the minister can make regulations, so not having to go through the full regulatory process, but can introduce regulations prescribing conditions that may also be fair use. So again, here we see this desire by the legislature to base and base fair use in Israel in that, of course, at that point didn't have case law in and sort of have a helping hand, as it were, to steer how the courts and businesses, etc., might use fair use. So that was intentionally done to increase certainty. And although this provision hasn't actually been used, we are aware that in 2002, the Ministry of Justice issued an opinion that AI was fair use. The only exemption to that was in the case where an AI model is trained on the work of just one author and the output competes with the works of that author in the same marketplace. So talking to our national experts and doing the literature review, we could see a number of positives that came from its introduction. One was mass digitization. So the Israeli National Library has used fair use to facilitate its large digitization projects, supporting filmmakers who use snippets and extracts from films, copying for educational purposes. From case law, we can see is fair use, as is making available online newspaper articles. One interesting development that was again pushed primarily by, I think, Israeli academics and librarians in the university space was the development of the 2013 Code of Fair Use Practices. So this outlined the kinds of uses that it was believed would constitute fair use, again, as a way of introducing certainty when it was unclear, due to a lack of case law, what fair use actually sort of meant at that point in time. So sort of turning a bit more to the jurisprudence, based on this article that we see from Neva Elkin-Corrin and Neil Weinstock, between 2008 and 2018, there were 55 fair use rulings. Sorry. And from that, we can see that the courts adopted a relatively conservative approach, that they, for example, imported, which we don't see in the States, sort of the importance of acknowledgement. So this view that moral rights is an important aspect, and therefore, if you acknowledge the rights holders, there is more chance that that use would be fair use. So Elkin-Corrin and Netanel characterize the response from the courts as being a conservative one, which led to fair use being rejected in 71% of the cases. Unlike the States, commercial use slightly disfavors a finding of fair use. As I said, there's strong emphasis on moral rights. The opening paragraph, the preamble, is treated like a closed list by the courts. I think the view is that will probably change over time. And the Supreme Court in particular was sort of imported oven ready from the States case law. So those are the findings regarding Israel. Oops, sorry. So Singapore is Danusha. So let me share the screen again.
Okay, thank you, Ben, and hopefully everyone can hear me. So I'm going to take you through Singapore and then Sri Lanka, and we will also keep the same set of slides up, and Ben will take us through, and then we will have Ducky present South Korea, and then Ben, but we won't share and unshare from now on. We will just keep the same set of slides up going forward. So with Singapore actually first introduced an open norm actually in 2004, which was a version of USA's fair use. And then it was updated more recently in 2021. Actually, Singapore originally was motivated to introduce an open norm for economic reasons. And it was as a result of Singapore joining the TRIPS agreement in '94 and then entering into a free trade agreement with the USA in the early 2000s. More recently in 21, we see that Singapore's copyright landscape had matured, and the reasons in 21 were slightly different to the reasons in 2004, because the reason for introducing an open norm was really to kind of a desire to pave the way for creators, and also to create an environment conducive to creative works and progressing research and development in the copyright industries. So if we go to the next slide, I'm just going to go back a little bit in time to 2004 again. And just to give just to provide some context. So even though Singapore introduced a US style open norm in 2004, really continued to label its open norm as fair dealing. And this, to really understand this, we have to also understand the history of Singapore, because for a very long time, Singapore's copyright exceptions were modeled on Australia's fair dealing, which was actually modeled on UK's fair dealing provision. So it was a bit restrictive, it's actually quite restrictive. And also another interesting fact about Singapore is that even though Singapore adopted the USA's model, which has 4 factors, Singapore's version had a 5th factor, which was the possibility of obtaining the work. This 5th factor was seen to be quite complex. It was actually difficult to apply. And importantly, in the 21 bill, that 5th factor was removed. So as we move forward in Singapore from 2004 to 2021, there's been a lot of change. It's been a lot of improvement. And the current law, which is the 21 amendment, now actually uses very closely the US's 4-factor model and also calls it fair use as well. Next slide, please, Ben. Okay, so the main provisions of fair use in Singapore, it is set out in Part 5, Division 2, and it is set out in fact, 5 sections. The key section here is 191, which is the key provision relating to the fair use 4 factors. And there's also 194, which relates very much to research and education. But why Singapore is different to other countries is that in most other countries, you will see this flexible copyright exception in one section. It's broad, it's fairly general, and like I said, it's contained in this one single section. But in Singapore, you can see that it actually is, it is in few sections. It is also more structured, and in some ways, it provides a more detailed rules, as well as giving that very general fair use exception in a single section. So it kind of, I think, achieves the best of both worlds. Next slide, please, Ben. So the other kind of developments which we have seen as a result of a flexible copyright exception coming into being in Singapore is that Singapore has benefited from having a text and data mining exception. It's also allowed for Singapore to digitize at-risk collection, paving the way for repository for various digitized collections. And also, it's really paved the way for having open-ended liberal education exceptions. One thing to mention about Singapore is that there's been no case law that we have seen from the 21 Act, which is very recent. So I think that's understandable. But also going back in time, there isn't really a lot of case law to go by in terms of guidance, even from the 2004 Act. So we do have limited literature on kind of the case law, but also one of the questions that we of course looked at is that, did, for example, Singapore benefit at all during the COVID pandemic because of the fair use like exception that they had? We did have very limited literature on that actually to give a very definitive answer. But what we see is that actually it was done. There was a kind of rapid movement to the education sector, but there isn't sufficient evidence to back that up in the library sector. Although we have seen some, it was considered in the library sector. Next slide, please. So just to kind of conclude on Singapore, what we see in Singapore is that second iteration. So there was a 2004 amendment, which kind of firstly introduced the fair use. But as I said, it's still stuck in the past, like calling it fair dealing, having a fifth factor, which was confusing. But with the 21, actually it removes some of those challenges. The current law is easier to understand and apply, as our national experts told us. It's had a positive impact on education in particular. So it's really opened up the education sector. It's made sure that Singaporean society is future ready, and Singapore has actually really progressed very much in the creative industries, and having an open norm, having these flexible exceptions has allowed for the creative industries of Singapore to really thrive and progress. And finally, it has allowed Singapore to embrace innovation and like transformative uses, parody, text, and data mining. The real impact of it, of course, I mean, these are some of the impacts, but I guess the greater impacts of that and the long-term impact we will not know for a while, because we are only like 3 years away from the introduction of the amendment, but I'm sure we'll get to know that in a few years to come. And so that's a little bit about Singapore, but moving on to Sri Lanka, we can also, give you some idea as to how Sri Lanka has gone about adopting an open norm. So Sri Lanka, I should say, is a mixed legal system, which is influenced by both English common law as well as Roman Dutch law as well. And Sri Lanka introduced its first IP Act in 1979 and was updated 25 years later in 2003. And in fact, in the 1979 code, there was a section called fair use, but very similar to Singapore, Sri Lanka also, influenced by UK's fair dealing provisions, continue to call it fair dealing, even though, for example, there was this kind of a small section on fair use, but really it was really being called fair dealing and very much was set in the fair dealing, was very much in the fair dealing mindset. And also similar to Singapore, Sri Lanka was also motivated for economic reasons. First of all, as a result of Sri Lanka joining the TRIPS agreement in '94, and then thereafter entering into a free trade agreement with the USA during the passage of the 2003 bill. So that was the motivation for Sri Lanka actually introducing an open norm, both in like earlier on in, for example, '94 and then 2003. Next slide, please, Ben. So Sri Lanka's open norm, the flexible exception, is set out in Section 11 of the 2003 Act. However, it does have tones of fair dealing within it. And I have given the quote from that section, which you can see that it says that, that it says fair use of a work, including such use by reproduction, copies, or by any other means. It can be done for purposes such as criticism, comment, news reporting, teaching. So these are like tones of fair dealing. It's not necessarily how an open norm should be. However, there is an open norm in Section 11, subsection 2A to D, where the 4 factors modeled on US's fair use is set out, and it says when a work should amount to fair use. But a key factor in Sri Lanka, and I would say Sri Lanka is a good case study in terms of learning some lessons for countries that are thinking about introducing more flexible open exceptions, is Section 11.3, because Section 11.3 states that the acts of fair use shall include the circumstances specified in Section 12. So really, the fair use, US's fair use like exception, which is set out in Section 11, is subject to Section 12. And I'll expand on that in my next slide, please. So Section 12 has 10 subsections. So what we understand from Sri Lanka's fair use provision is that if a work does not fall within the 10 subsections in Section 12, then the open norm in Section 11 will fail to apply. So this is problematic because now you have an open norm. It's wonderful, it's flexible, but it is subject to an exhaustive list and to an exhaustive list that has 10 circumstances in which it can apply, which means if it does not fall within those 10 circumstances, then it cannot apply. And also it does not define what is meant by fair use, but it sets out the acts which constitutes fair use under Section 12 and those which do not. So this is really problematic, I would say. And it's kind of similar in the sense that Sri Lanka has the 4 fair use factors, but different to the US's model because it is subject to that exhaustive list in Section 12. So in fact, if I go to the next slide, please, I'll kind of expand a bit more. So this kind of reflects the challenges which could be faced when moving from a restrictive fair dealing system to a fair use system. And also, as our national expert said, currently the doctrine of fair use is very restrictive when you compare it with the original nature and scope of the doctrine, and has led to much uncertainty. And if you were to overcome that, like so a system like in Sri Lanka, what we can do is, or what you can have, is a general rule that applies in the absence of any of those specific instances which are set out in the exhaustive list, so that there's always a fallback open norm provision. So far, when we looked at Canada, Israel, Singapore, we saw like very successful stories there of how open norms have worked and how you can adopt open norms for the benefit of technology, education, research, library sectors. Sri Lanka, there has been some challenges or some lessons to be learned. And the greatest lesson is not that Sri Lanka has failed in adopting it. It's actually a drafting issue. The way the legislation has been drafted has meant that actually the open norm is subject to an exhaustive list. So it's a drafting issue, not the fact of any other kind of reason. But if you can draft the legislation well, then obviously that's the lesson to be learned. Then there can be a very successful open norm. So with that, I'll hand over to Ben to go through, I have one more slide on Sri Lanka, which is that there's a lack of case law in Sri Lanka, so we can't really have much guidance by judiciary. And while Sri Lanka moved very rapidly to providing material during the pandemic, and there's some great literature on that as well. Again, like Singapore, it was not supported. Like we cannot say there's not enough evidence to say that was supported by the open norm. So thank you, and I'll hand over to Ben. To hand over to Ducky to go through South Korea. Thanks.
Thanks, Dinesha. So South Korea. So South Korea is one of the several countries we investigated in this report. And South Korea also shows a very interesting development in terms of like introduction of open norms. So South Korea introduced open norm with a US style like open norm, like a US style fair use provision in 2011. And the motivation behind it is that the country wanted to have like increased the flexibility of copyright exceptions in the rapidly changing copyright landscape, and because the driven by the proliferation of the internet and all these digital technologies. So quite interestingly, there was not much opposition from like the industry or governmental officials. On the other hand, actually, like in contrast, they got like more support from academics, governmental officials, and industries, because there have been some research on the positive side of open norms in South Korea in an academic level and also like the governmental level. Therefore, most people were happy to introduce open norm into the domestic law. And also what I'd like to highlight here is South Korea being a civil law country had no effect on introducing an open norm. It's as Dinesha already mentioned in the beginning of the this event. sometimes there's a myth that actually the civil law countries is not really, doesn't go really well with the introducing open norm. But I just wanted to highlight that was not the case. However, South Korea, in introducing this open norm, there have been some challenges. And one of them, mostly it's about the legal structure of this open norm with other exceptions, and also courts, like the judiciary's approach to this open norm. So basically, there was an overlap with the quotation exception that was used as a almost like quasi open norm even before the introduction of US fair use like a style provision in Korea. And also another problem was the courts, they took a very conservative stance against the requirement of the fair use provision in Korea. That's why there were not many like useful precedents that gives like how much they can extend the interpretation, extend the scope of the provision and how they apply it to some situations. So can you go to the next slide, please, Ben? So if I show you the construct of this Article 35.5, fair use of works. So the section Article 35.5.1 says without prejudice to Articles 23 through 35.4 and 101.3 to 101.5. These are basically other statutory exceptions in copyright law in Korea. And without prejudice of them, where a person does not unreasonably undermine an author's legitimate interest without conflicting with the normal exploitation of works, he or she is entitled to use such works. So basically, Article 35.5.1 is almost like the replication of the three-step test, like a Byrne and the TRIPS three-step test. And if you can see Article 35.5.2, it says in determining whether an act of using works fall under paragraph 1, the following matters shall be considered: purposes and characteristics of use, types and purposes of works, amount and substantiality of proportion used in relation to the work, to the whole works, and effect of the use of works on the existing or potential market. So basically, as you can see, these criteria are quite similar to the US fair use provision. So I'd say this construct is more of the combination of the three-step test and the fair use provision of the US one. Can you go to the next, please? Yes. So as I mentioned, there were some challenges in Korea, which was basically it had some issues and overlap with the existing quotation exception. So the quotation exception was almost used as a semi-open norm in Korea, even before the introduction of fair use in South Korea. So Article 28 says works already made public may be quoted for news report, criticism, education, research, etc., in compliance with the fair practices within the reasonable extent. So what happened in Korea in 2005 was that the Supreme Court tried to interpret this provision liberally to extend the meaning of the quotation here. And also they introduced some new criteria they can use for assessing fair practices within the reasonable extent. And that criteria were virtually identical to those for US fair use and the current South Korean fair use. So if I give you a bit of background of this Supreme Court decision, then it's called like the internet thumbnail case. So this case, the factual background is almost quite similar to the US case called like a Perfect 10 on Amazon. So the person tried to like just use a photograph in its entirety and just for indexing purposes on the internet website. And the court said using someone else's photograph without their permission is allowable under the quotation exception. So this case, the similar factual background was decided in the US in accordance with the fair use. However, in Korea, it was decided almost the same conclusion was reached in accordance with the quotation exception. However, this was a problem. Why? Because the quotation exception existed before fair use. And then when fair use came into the domestic law, there was a bit of confusion where we should draw a line between the two provisions, because quotation exception somehow served as like some sort of open norm here. Of course, there was some, criticism that, it is inappropriate to interpret the meaning of quotation to that extent, because the meaning of quotation has to be quite strict. However, the problem was, as I mentioned, it was the court's rule to interpret and also give like some clear guidelines of the meaning of the quotation and fair use. However, the court failed to do so. That's why there is still a bit of like confusion whether these two, like how much do they overlap, or which one should take precedence and stuff. Can we go to the next slide, please? So this is exactly what I said. So the courts, they although they understood the importance of like a fair use, however, they didn't really give enough and sufficient useful precedents to interpret the meaning of the fair use requirements. At the same time, they didn't really give much the explanation where we draw a borderline between the quotation and the fair use exception. Therefore, sometimes the court considers both exceptions at the same time. Although theoretically we understand fair use could be quite useful because the scope should be like a much broader than the quotation exception. However, although like this is like a theoretical observation, the court did not really confirm that that is the case. And also court conservative interpretation of fair use requirement has been also problematic because the court tend to interpret the provision like word by word and very restrictively. That's why sometimes when there's like a bit of like, commercial use of someone else's work, they are very narrow. They take like a very narrow and restrictive of application of fair use in those situations. So since the introduction of fair use in 2011, there have been approximately like 60 decisions. However, as I said, there is not enough detailed ruling on the requirements of fair use. And also because of that, there haven't been much active use of fair use in practice. So the takeaway from this experience is that introducing open norm was quite useful in Korea in terms of like expanding the scope of like a quotation exception. Also, it could be quite complementary. But the judiciary's role is also very important. They have to be very active to interpret the scope of this new provision to make it really work. Next slide, please. Yeah.
Okay, so now moving on to Japan. In a sense, Japan represents a third way. So we've had Canada, which amended through case law, sort of expanded fair dealing. Then we have the countries that introduced fair use. And Japan has moved not to introduce fair use, but to introduce two flexible exceptions. And starting off with the background for this, as everyone knows, Japan is known for its cutting-edge technology. But with the search market and the growth of the internet, there was a growing realization that Japan was not expanding in the way that it had in sort of other technology markets into e-commerce markets. So, for example, Yahoo is and was the biggest search engine in Japan. And again, we saw the companies like Amazon stepping into Japan, whereas traditionally, if anyone's been to Japan, they will know that everything other than e-commerce is supplied by and manufactured by Japanese companies. So sort of the failure to expand into e-commerce markets really kind of caused a crisis of confidence in some senses, and therefore the view was that copyright was an inhibitor, and Japanese companies were actually setting up, online companies were setting up in the US in order to shelter under fair use. So from the early 2000s, we saw an increased discussion around the introduction of Japan fair use. And structurally, Japan is quite interesting because the Prime Minister chairs the Intellectual Property Strategy Headquarters, and the IPSHQ is made up of all Japanese cabinet members. So their job, as it says, is to sort of set the direction for intellectual property law in Japan, and they repeatedly, from 2008 onwards, called for the introduction of fair use. However, at the operational level, the Agency for Cultural Affairs, Bunkacho in Japanese, repeatedly ignored the calls coming from the Intellectual Property Strategy headquarters. Around 2015, we saw, again, at the strategic level, a massive focus on AI, big data, Internet of Things, etc., with a number of government reports. And the Japanese government introduced the concept of Society 5.0. And Society 5.0 is essentially a society where technology supports people. And Japan is particularly challenged in terms of earthquakes, as we know, a rapidly aging population. So the idea was Society 5.0 would be a society which is supported by AI, big data, Internet of Things. This then resulted again in the Bunkacho revisiting the call for fair use. And pivotally, in 2017, they did a survey which had hundreds from memory, if not thousands, of respondees from organizations. And as you can see from these respondents, that there was broadly a desire coming from organizations to have a more flexible copyright regime. And the majority of people favored a broad exception with enumerated lists of the typologies of acts which would fall under under the general provisions provided by the law. So this led to the Japanese government to reject fair use, and in 2018 they introduced two flexible exceptions. So one, Article 34, as you can see there, 1, 2, 3 allows use of copyright in testing technologies, allows AI, allows sort of backroom computing uses, but it also allows, as you see in red, other uses. So essentially what it says is that you can use a copyright work for any purpose as listed below and any other purpose, as long as it doesn't involve human beings enjoying the thoughts or sentiments expressed in that work. Similarly, Article 47.4 has the same sort of formula, which is a list of activities which are permitted and a sort of a preamble which basically says the following activities, which again are all very technical, communication oriented, are allowed, as are other similar activities. So from a jurisprudential perspective, we can see that Article 34 is very interesting because it actually defines the scope and purpose of copyright law in Japan. And the purpose of copyright law in Japan is for people to enjoy intellectually and emotionally copyright works, and anything that falls out of that essentially falls outside of the scope of copyright law. So unlike Europe, certainly the copyright's key, where there is not, to my way of thinking, a key steer what the purpose of copyright law is for. In Japan, post 2018, we know the purpose of copyright. So moving beyond law, we can see that there's a strong desire to support Japanese business. This is very much business led to support Japanese businesses. From our national coordinators, from all the research we've done, we can see that it was well received by Japanese businesses themselves. And again, it's been introduced recently, but there has been no litigation around this. So that's Japan.
All right. Thank you, Ben. So I will conclude now with the conclusions arising from the project, and then after that, give our recommendations, leaving sufficient time for any questions or discussion that you may like to have. So we have basically looked at 6 countries in depth, or in the time that we have. Canada, Israel, Singapore, Sri Lanka, South Korea, and Japan. And we started with the USA in the sense that only to sort of mention USA's fair use model, and it being an open norm. So in our project, we really looked then at how countries have adopted similar models or different models, like just as Ben said, very different way of where Japan has done it, or even Canada that broadened the existing fair dealing. So starting with Canada then, what we can conclude then is that it's not always necessary to transplant an open norm or fair use provision into one's jurisdiction, because it is possible to broaden an existing provision and successfully apply it, as we saw with Canada. But what we also saw is that for this to be effected, a liberal approach by the judiciary is needed. So while we see Canada as a success, and in everything that you see here in light green, we recognize it as a success, and our research has pointed out it as a success. Then Ben looked at Israel, and here we see one of the really benefits in Israel, and also another success story is that complementing an open norm with ex-ante intervention and guidance by a government and a rich body of case law can really illustrate how an open norm can be interpreted and managed well. So the way Israel has done it is, again, slightly different. It is still based on the US's fair use model, but by having that ex-ante intervention by, if you can go back to the previous slide, Ben. Oh, sorry. Yeah, if you see on this slide. So, yeah, sorry, if you just stay on the slide. Thank you, Ben. Yeah, so basically what we see is that ex-ante intervention and guidance by the government and rich body of case law really kind of contributed to the Israel's success. Thereafter, I looked at Singapore, and here what we see is with Singapore is slightly different. In most of the countries, it was a single section, but with Singapore, you have one single section of a statute, but also demonstrates how, along with that, having that kind of a single section, it can also be drafted in multiple sections and complemented by clear examples and guidance. So being a bit more prescriptive, but at the same time being very open as well. So again, Singapore is a success story, and one again that other countries like European countries can really learn from in broadening your copyright exceptions in your own countries. So if you go to the next slide, please, Ben. So here we have slightly 2 light orange boxes, which are, I think I wouldn't like to call them challenges, although there have been challenges in these countries, but really lessons we can learn. And I think these are great case studies and lessons which can be learned both from Sri Lanka and South Korea. So with Sri Lanka, what we saw is that it is the language and the drafting that is of clear importance here. And drafting an open norm is a very important thing, and doing it clearly is important. And if not done properly or effectively, then it can lead to the open norm being undermined. And that is what we saw in Sri Lanka. So there was no hesitation adopting the open norm. There was no hesitation in, like, in fact, wanting to use it and having that kind of thinking at the outset. But it was the drafting that has let Sri Lanka down. So for now, it cannot be used very well in practice, but it's a lesson that we can all learn. Secondly, with Korea, what we see is that with South Korea, which Ducky presented, what we see is that there was already a very successful quotation exception in place. And so in that kind of situation, you can be sometimes spoiled for choice, especially where the judges have been using such a flexible exception for many, many years, then introducing an open norm could also be a challenge for judges, and that was one of the cases with South Africa. So the overlap between the two has been a little bit complex, and maybe has led to some uncertainty and confusion, and that conservative approach, which Ducky talked about as well. However, what again we can learn from this country is that it is a lesson to be learned. So South Korea, a civil law country, a great example of a civil law country adopting an open norm, but simply about, how do you go about it? If you already have flexible exceptions, then what kind of things can you be mindful of? And Ducky also presented about various things that South Korea is currently doing to mitigate those challenges. And then Japan is a very interesting example because went a very different way, a third way, to all other countries and introduced an open norm that is specific to Japan's needs, and again has been very well received in Japan, particularly by businesses, and generally it's seen as flexible, although slightly restrained a little bit by this purpose, which they are led by. But all in all, we see that from the countries we have looked at, most of the countries, as it's a success story. There are a couple, even though I've said they are challenged, which we can certainly learn lessons from. So as we conclude our presentation, also our report, we have presented some recommendations. So if we go to the next slide, please, Ben. Our recommendations, as you see here, so we do recommend the adoption of open norms in other countries around the world, particularly and including in European countries. Particularly as European countries are industrialized and highly developed, they are especially likely to reap the rewards and the benefits from having this kind of open norms in copyright law. Also, the flexibility of open norms allow copyright laws to be balanced, and that is such an important thing, whilst moving with the times currently, without abandoning the principles of the Berne Convention. So again, we again recommend that there are sort of kind of these benefits and why open norm therefore should be adopted. And as has already been mentioned, the legal tradition in countries, whether it be common law, civil law, hybrid or mixed, was not a factor, has not been found to be a barrier to successful implementation of the open norm. Rather, it's sort of like from the two countries that you saw in orange there, it's a drafting of the law. Or, for example, where, for example, there's been another exception that's been used more widely that has really had the impact of whether it's been highly successful or not. Next slide, please, Ben. So finally, just to end with, to say that with open, our final recommendations are that, it avoids countries having to wait significantly long periods of time to amend or introduce a new technology-driven copyright legislation by having these open norms. And also, as we said at the beginning of the presentation, hopefully you have seen as well through introduction of new exceptions like text and data mining, allowing parody, allowing other kind of areas to really thrive in the creative cultural industries. What open norms have done in these countries is they have allowed those countries to easily adapt to technological change and progress innovation, and therefore become more economically competitive. And we really see that a lot with countries like Singapore, with Canada, with Japan, Israel, and even South Korea. That's really allowed that as well. So I think it's fair to say, as we conclude this presentation, with open norms, there's much to gain and very little to lose. And therefore, we highly recommend the adoption of open norms. And we think that, that will really allow the copyright landscape to really thrive with that balancing that the open norms bring. So with that, I'll bring this presentation to an end and really happy to take your questions. Thank you.
Thank you very much, Danusha, for a fantastic presentation, and thank you obviously to Ben and to Ducky as well for all the work. And I'm conscious that the amount of work in terms of understanding the experiences, the reasoning behind moving to open norms elsewhere, it's very considerable. But I'm conscious that this is really a unique piece of work, something that we talk a lot about fair use, and it gets litigated and and argued about a lot, but actually having all this brought together really does make a big difference. So we've already got a couple of questions in the chat, and so I will start with these. The first one, I'm going to broaden a little bit. I'm going to use chair's privilege here, asking about, and the question focuses on whether there's any case in Japan of discussing the three-step test in relation to flexible exceptions. I'm going to broaden it. I know that Danusha, you talked about this a little bit at the end about how moving to open norms is compatible with the three-step test as set out under Berne. I don't know if you could say a little bit more about that, about the degree to which the three-step test was considered when passing these laws, and how countries decided nonetheless to go ahead and felt that actually introducing fair norms didn't cause any problems with the three-step test.
Yeah, I mean, I can say it in a broader level, and then for specifically for Japan, I suppose I can pass on to Ben. So with each of these countries, which are of course signatories to the Berne Convention, and as I said at the very beginning as well, it has been confirmed that open norms are very compatible with the Berne Convention. Of course, we saw with the when USA joined the Berne Convention and in the TRIPS agreement, and also during the WTO ruling. So with each of these countries, there wasn't any kind of, from our research that we found, any kind of contradiction or any problems that was caused. They are all, whether it be Sri Lanka, Singapore, South Korea, were all seen to be, basically there was no issues or challenges in introducing the open norms. So I think we can safely say that if countries were to go down this route, then, from the experience that we have reflected and shown, I think it has been a smooth process. For Japan specifically, maybe I should hand over to Ben, because Ben is the researcher who really looked at Japan more closely. So Ben, can I please hand over to you for that? Thanks.
Can you see the slides?
Yes, if you can. Yeah.
We can see the back end.
Okay, so there isn't actually any case law, as I said, on the introduction of either of these two open norms. One of the questions outside of this study that I had was exactly this, whether there were any issues around the three-step test and whether that was even discussed in the run-up to its implementation in 2018. And the answer from one of the academics and individuals who was involved in the government committees was that no, the three-step test was not seen as an issue. And if you actually look at the preamble at the top, you can see that what the legislature did was actually incorporate the three-step test into Article 34. So as you can see, it says, however, this does not apply if the action would unreasonably prejudice the interests of the copyright owner in the light of the nature or purpose of the work or the circumstances of its exploitation, which is the Japanese implementation of the three-step test. So if you look at the official or non-official Japanese versions of the Berne Convention, as it is essentially the same as the Japanese that you will see in Article 34.
Excellent, thank you very much. So I'll move on to the next question, which we have down there. So we have a question about the how AI and what's the relationship, the relationship between open norms and AI. I know that, for example, Ben highlighted the guidance provided in Israel about AI being legitimate under fair use. I think he mentioned in particular a really interesting aspect to that about actually trying to carve out the situations and being clear about when it wasn't applicable. I think it's a particularly interesting area, given that certainly what we're seeing coming out of Europe at the moment risks being incredibly broad brush and not allowing for much nuance or focus on actually the downstream impacts that AI might have. So I think I don't know if Ben and others want to go into more depth about how open norms, how AI might fare, where AI might fall, AI uses may fall under open norms.
So we know in the United States, for example, that certainly what's called text and data mining, so analytics of material is fair use. We can see that from a number of cases, two of which involve Google and one which involves Turnitin. So it's very clear from the US case law that data analytics, text and data mining is lawful. We obviously have a number of cases looming in the States about what is called generative AI. In sort of in copyright circles, in technology circles, generative AI actually means something slightly different. In Israel, we saw the Ministry of Justice issuing an opinion saying that AI was fair use. The only exception to that was where one person's work was being used and the output is used in the same market as the inputs. And then I think, as I showed in Japan, essentially AI was one of the big drivers. Commercial AI primarily was one of the drivers for the introduction of Article 34. So again, we see it in Japan. I will hand over sort of for views and comments on the other jurisdictions that we covered to colleagues.
Yeah, I think one thing to say, and of course we discussed this, apart from countries like Israel and also USA, a little bit also Japan, I think with countries in Asia, I think one thing to note as well, like for example, in Sri Lanka, the open norm was introduced in 2003, South Korea in 2011. And of course, AI is, with the development and the rapid development of AI, at least in these countries, in Sri Lanka at least, there hasn't been so much movement. But having said that, for a country like Singapore, which is a more recent development in 21, that is a country where there has been a recognition or like an attempt to see whether, and I think I mentioned as well when I was presenting Singapore, how the existing open norm can really embrace this type of technological advancement. Having said that, I think that with AI, it's actually quite, I think Israel is probably the only country, I would say, that apart from USA, where that really interesting example was given. Apart from that, I think a lot, like for example, just only 2 months ago, we had the EU AI Act. I think a lot of countries are looking at how this rapidly moving technology can be regulated, and whether even through existing norms, we can, open norms, we can do that. So there will always be countries that might benefit more, and I think other countries are still trying to like catch up. And I would say countries like Sri Lanka, for example, are still on that catch up. But countries like, I think I'll pass to Ducky for South Korea, but for example, Singapore has looked at how to embrace, but I think it's still also trying to grapple with the extreme rapid advancement of this new technology, as we understand from our national experts.
So from the perspective of South Korea, I would say obviously the introduction of open norms was to prepare for the emerging technologies, including AI and everything. So on a theoretical level, we all understood, like the Korean government and the policymakers, the academics, they all understood that the open norms would be very helpful to implement AI in an efficient way. However, as I presented in my part, there haven't been that many cases that we could actually draw on from, especially like, there was no case, as far as I know, there was no case on AI or per se. So I can't really say for sure whether how AI will be perceived under the development of open norm in Korea, but definitely I would say there's possibility as potential that open norm can be very useful to use and to take advantage of the AI technology.
Thank you very much. I think we're all aware this is an emerging field, and of course also that copyright is not the only tool that legislators have when looking to regulate the progress of AI as well. And so, yeah, that's good. I think also just following on from that, and again, picking up, for example, on points that have been made previously, and this is also something that's highlighted in the question. I think the question of how fair use treats distinctions or a lack of distinction between commercial and non-commercial uses is an interesting area to explore. Certainly, experience in EU law indicates that EU law often contains this quite strict definition that you can only do things for non-commercial purposes. Whether that's a realistic or a meaningful distinction is a question that has been highlighted in wider efforts to look at the validity of the current setup of research exceptions we have. I don't know, it'd be great if you could go into a little bit more depth about how under open norms that question of commercial versus non-commercial and how the sort of fuzziness of that boundary is dealt with.
I was going to ask Ducky, do you want to take it from South Korea? Because I know South Korea has really looked at this in quite a bit of depth about the conservative nature, but then we can also look at the other side of the coin as well.
Yeah, I mean, when it comes to South Korea, it's I think the what really mattered was because when we interpret, for instance, when we interpret the law, then we really need some predictability, certainty. We need some, for instance, some guidelines and stuff like that. Sometimes when the court approaches like very conservatively, the actors, real actors who can benefit from open norms, they can't be so certain whether they can take advantage of open norms or something. So there were many discussions how we tackle this. For instance, one of the things that that was brought up in our in a meeting with the national expert was that how about we create like a guidelines that actually could involve everybody, the judges, other industry stakeholders, and everybody, because it can be very useful to actually find the very good line between the actors. So I think that was one of the approaches as well, and also because open norms is becoming almost like the worldwide like I do say like what almost like it's a globally accepted like a practice, which means that sometimes like having some sort of like workshops across the countries that can understand from each other. So I don't know if I answered the question, but yeah, that was kind of the approaches that were taken in South Korea.
Thank you. I'm going to ask one more question, but I don't know if Tanusha or Ben wants to react on this commercial, non-commercial point quickly.
Yeah, sorry, go on, Ben.
I was just going to say, obviously the EU is an outlier because as I think, by introducing fair use or the general exception that we saw in Japan, there is no distinction between commercial and non-commercial research in the main.
Yeah, I was going to mention the same thing.
But I think that's that's a particularly powerful point. I think just underline, yes, I know that this assumption that this is a normal thing is not necessarily correct. I think on the topic of the EU, and this is the topic of my final question. I of course encourage the panelists to take a look at the other questions that are in the Q&A function and answer directly. But I suppose given the focus of Knowledge Rights 21 on trying to shape a more positive, more usable framework for researchers, for educators, the libraries that support them in Europe, what options do you see, what possibilities do you see for introducing an open norm or reading an open norm into the laws that currently govern in Europe, and most obviously the InfoSoc directive?
Sorry, can you repeat the question, please, Stephen? It wasn't very clear.
Of course. So what scope, what possibilities do you see for introducing an open norm, a flexible exception into the EU, given the state of, given the laws that currently apply there?
Yeah, I mean, I'll take this and then maybe pass on to the others as well. I think there's a lot of scope, and it's also about countries' desire, I think, to consider the balancing of the rights and, on the one hand, obviously having that protection, but also giving greater user rights. And I think we are in a great moment now where the creative cultural industries are really progressing. So yes, we do have a set of laws currently. We have the InfoSoc as well. And of course, there's a basket of exceptions there already. But as we have seen with these countries, they have the the countries that we looked at, they have really transitioned, and quite successfully, in very different types of ways. Some where they really focused on why they are doing it. It is really to address business interests, and where they felt that, for example, a country is being left behind because the current exceptions are being quite restrictive. So, is it that, or for example, the current exceptions are slightly restrictive. We don't have to kind of change it completely, as we saw with Canada, where you can take a more broad approach with the judiciary, and therefore in that way, or through, for example, ex-ante intervention as well, by guidance, you can broaden what you already have. So I think there's great potential. It's also identifying what the need of that country is. And I think if we look at Europe, I think where there is so much movement currently, both in terms of the creation of these and the advancements and the creative side, but also the need to build on that through the users, then I think this report hopefully gives that idea and gives a reflection of the different ways that a country can look at what its needs are, what it needs to move towards, and then how it can be done. And then, of course, the successes that it can have as well. So I'm not really going to each country as such in EU as to say, but I hope that, that kind of gives an idea as to, that it can be done, and also how it can be done. I don't know whether Ben and Ducky wants to add anything else as well to it.
Yes, so I guess the quick answer is there's absolutely nothing in the UK, which has left the EU, of course, that stops it from introducing fair use, Israeli fair use, US fair use, maybe not Sri Lankan fair use, but Singaporean fair use, and of course the Japanese exceptions. In terms of Europe, as you said in the question, we're obviously limited by the Information Society Directive. But I think, we can support research, including commercial research, to the maximum in member states. And what member states can do is introduce the quotation exception, the very broad quotation exception that we see in InfoSoc. And of course, also 5.3a, which allows non-commercial research. And it allows not only reproduction, but communication to the public. So I think introducing those very broad, general sorts of exceptions that we see in InfoSoc, and ensuring that they're not overridden by contract or by technological protection measures, is something that every member state can do, and it sits within the boundaries set by InfoSoc. So I think, that's, without something changing at the European level, that's, if you want to support research, innovation and technology to the maximum allowed by the Copyright Directive, that's one thing that every country could do.
Thank you very much. Perfect. So I'm conscious that we are already over time, so I think that's a really powerful message to end with, that actually there's a lot that we can do within current legislation that maybe doesn't require overall reform, but just a different approach, the support, the guidance to actually make it happen. So with that, I'm going to close the webinar. The link to the report is in the chat. The recording will go online as soon as possible. But I hope everyone's come away with a sense of the power and the potential of open norms to achieve a whole range of policy goals, including, importantly, supporting the creative industries. And we'll actually be able to use this in your own work, but also to start to think about how can we do copyright differently? How can we think about the values and the policy goals that are supported by reinforcing the interests and the rights of users? So with that, thank you very much to Danusha, to Ducky, to Ben, for all of the work carried out. Please do take a look at the Knowledge Rights 21 website, sign up for our newsletter. We've got other reports coming out shortly, which I hope will really help bring some more evidence, bring a more fact basis into discussions in this area, and help to make sure that we realise the potential of properly balanced copyright in order to achieve a whole range of goals that will make Europe and other countries stronger, more sustainable into the future. So thank you very much, everyone, and I wish you a very good afternoon.